Hello, myself Nikita Shinde. In today's video, we are going to learn part 3 of the Indian Constitution, which deals with the fundamental rights. In this video, we are going to learn right to the freedom, Article 19 to 22. Before starting the video, I would like to request you people to subscribe my channel and turn on the bell icon so you couldn't miss any update from me. So I begin here. Right to freedom, Article 19 to 22. The right to freedom guarantees freedom for citizens to live a life of dignity, among other things. These are given in Article 19, 20, 21, 22 of the Indian Constitution. We shall take up the articles one by one in this section. Below we provide the associated articles of the Constitution under the right to the freedom. The Article 19 protection of 6 rights concerning the freedom of speech and expression, assembly, association, movement, residence, profession. First, freedom of speech and expression. The state guarantees freedom of speech and expression to every person of India. However, the state can impose restriction on the freedom of speech and expression in the interest of the integrity and security and the sovereignty of the country. Friendly relations with foreign nation for public order with respect to the defamation, incitement to offense और contempt of court. मतलब freedom of speech and expression है, लेकिन उसके ऊपर certain limitations है. उसका अर्थ नहीं कि वो कुछ भी बोलेगा व्यक्ति. There are certain limitations or restrictions on this article was on the freedom of speech and expression. Second, freedom of assembly. The state guarantees every person the freedom of assembly peacefully without arms. However, as above, reasonable restriction can be imposed in the interest of the sovereignty and integrity of the country and public order. Freedom to form association. Third is freedom to form association, and freedom of assembly means states what we can form an assembly in a very peaceful manner, and it also has certain restrictions to to save our sovereignty and integrity. We can't do anything like striking and all is not allowed. It's a freedom of assembly, not to do anything that's create harm to this our country or our nation or society. Freedom to form association. Third, again the state can impose restriction in the integrity and security and sovereignty of country. Friendly relations with foreign nation for public order with respect to defamation, incitement to offense or contempt of the court. This freedom gives workers the right to form the trade union, which is thus a fundamental right. मतलब जो फ्रीडम टू फॉर्म एसोसिएशन है उसके अंदर भी रिस्ट्रिक्शंस है. इंटीग्रिटी, सिक्योरिटी एंड सोवर्जिनिटी ऑफ द कंट्री, इसको मतलब बचाने के लिए उसके ऊपर तो ये दिए हैं. हम लोग कुछ भी नहीं कर सकते. इसका अर्थ है मतलब एसोसिएशन का फ्रीडम है हमें, तो हम कुछ भी नहीं कर सकते. इट हैज़ सर्टन रिस्ट्रिक्शंस एंड लिमिटेशन. द पुलिस फोर्सेस रिस्ट्रिक्शन ऑफ राइट्स. Act 1966 prohibits police personnel from forming trade unions. Second, the Constitution also allows the Parliament to pass a law restricting the rights to form political association to members of the armed forces, intelligence, bureaus person employed with the telecommunication system. Fourth, freedom to movement. A citizen of India can move freely throughout the territory of India, but the right can also be restricted on the grounds of security, public order, or for प्रोटेक्टिंग द इंटरेस्ट ऑफ द शेड्यूल्ड ट्राइब्स. हमें फ्रीडम है, वो फ्रीडम ऑफ मूवमेंट है. हम किधर भी जा सकते हैं, किसी भी टेरिटरी में जा सकते हैं, लेकिन रिस्ट्रिक्शंस है जैसे सिक्योरिटी, पब्लिक ऑर्डर के अंदर, क्योंकि वो प्रोटेक्टिंग द इंटरेस्ट ऑफ द शेड्यूल्ड ट्राइब. मतलब किधर भी जा सकते हैं, लेकिन कुछ रिस्ट्रिक्शंस लगाए हुए हैं. और उसके बाद फ्रीडम ऑफ प्रोफेशन है. ऑल सिटीजन्स इसके बाद फ्रीडम ऑफ रेसिडेंस है. Citizen of India have the right to reside in any part of the country. All the restriction can be imposed on the grounds of security, public order or protecting the interests of the scheduled tribes. मतलब व्यक्ति को किधर भी reside करने को allowed है. और उसके बाद फ्रीडम ऑफ प्रोफेशन, ऑल सिटीजन्स हैव द राइट टू कैरी ऑन एनी ट्रेड or profession occupation provided the trade or occupation is not illegal or immoral. Also, the law does not prevent the state from making laws related to the technical or professional qualifications required for practicing the occupation or the trade. फ्रीडम ऑफ प्रोफेशन, कुछ भी कर सकते हैं, कोई भी ऑक्यूपेशन वो लोग क्या बोलते हैं कर सकते हैं. और उसके बाद है आर्टिकल 20 deals with the protection of citizens in respect of conviction for offences. This provides for three types of protection of the individuals against the state. First, retrospective criminal legislation. This is also known as ex post facto criminal legislation. Under this, a person cannot be convicted for an act that was committed at a time when the act had not been declared by law as an offense. फिर उसके बाद this means that criminal legislation cannot be given a retrospective effect. This immunity cannot be used against the provision of preventive detention and also does not cover the trial. Third, the law also provides that a person cannot be subject to a punishment greater than what is prescribed by the law for the offense committed, and what we call, and in this second double jeopardy, this indicates that a person cannot be convicted for the same offense more than once. And the third is prohibition against the self-incrimination. This implies that no person accused of an offense shall be compelled by the state to bear witness against himself. मतलब जो रेट्रोस्पेक्टिव क्रिमिनल लेजिस्लेशन के अंदर ये तीन आते हैं, जो मैंने 1 2 3 बताया. दिस मीन्स दैट क्रिमिनल लेजिस्लेशन कैन नॉट बी गिवन रेट्रोस्पेक्टिव इफेक्ट. दिस इम्यूनिटी कैन नॉट बी यूज्ड अगेंस्ट द प्रोविजन ऑफ प्रिवेंटेड डिटेंशन एंड ऑल्सो डज नॉट कवर द ट्रायल. एंड द थर्ड, द लॉ ऑल्सो प्रोवाइड्स दैट अ पर्सन कैन नॉट बी सब्जेक्ट टू अ पनिशमेंट ग्रेटर देन व्हाट इज प्रिस्क्राइब्ड बाय द लॉ फॉर द ऑफेंस कमिटेड. और उसके बाद डबल जियोपार्डी है, पार्टी. Then उसके बाद prohibition against self-incrimination. And after that we have, and it's double jeopardy, okay. And next we have Article 21 states that no person shall be deprived of his life and personal liberty by the state except as per the procedure established by the law. This article has a wide scope and its interpretation has undergone many changes over the decades. The Supreme Court has interpreted the right to life as the right to a dignified life. This is the most important right in one sense, because without this right to life, all other fundamental rights would be meaningless. Article 21A. This article was introduced by the 86th Constitutional Amendment in 2002. It provides that the state shall provide free and compulsory education to all the children between the age of 6 to 14. In this article, it is mentioned, it was added by the 86th Amendment Act 2002, and it says that it is a compulsory education for the children between the age of 6 to 14. And then we have Article 22 deals with the protection against arrest and detention in certain cases. This article is applicable to the both citizens and the non-citizens. This provision extends certain procedural safeguards for individuals in case of an arrest. It comes into the picture after a person has been arrested. It is not a fundamental right against the detention and arrest. The idea behind the right is to prevent arbitrary arrest and detention. This article provides the following safeguards. Article 22, Clause 1. Any person who is in custody had to be informed as to why he has been arrested. उसको बताना पड़ेगा कि वो अरेस्ट है. और फिर further he cannot be denied the right to consult an advocate. और उसको पूरा हक है कि वो advocate के साथ consult करे. Article 22, Clause 2. The arrested individual should be produced before a judicial magistrate within 24 hours of his arrest. जो अरेस्टेड इंडिविजुअल है उसको जुडिशियल मजिस्ट्रेट के सामने 24 आवर्स में ये करना पड़ेगा, प्रोड्यूस बिफोर अ जुडिशियल मैजिस्ट्रेट विद इन 24 आवर्स ऑफ हिज अरेस्ट, बताना पड़ेगा, मतलब इन द सेंस आर्टिकल 22 क्लॉज 3 नो इंडिविजुअल हु हैज़ बीन अरेस्टेड कैन बी केप्ट इन कस्टडी फॉर मोर देन द पीरियड डिटरमाइंड बाय द जुडिशियल मैजिस्ट्रेट. Then these safeguards are however not applicable to enemy aliens के लिए applicable नहीं है. People arrested under the preventive detention laws. What is preventive detention? There are two types of detention, punitive and preventive. Punitive detention is detention after a trial. Preventive detention is detention without trial. The idea behind this is to prevent an individual from committing a crime. This means that a person can be detained on the grounds of suspicion. The rights of the people arrested in this manner are governed by the preventive detention laws. Here we complete right to the freedom, Article 19-22. I hope my video was helpful for you all people. If any queries regarding this topic, do write comment in comment section, and do like my video, share, subscribe and comment, and don't forget to turn on your bell icon. Thank you.